In the previous two videos, we discussed Article 124 of the Constitution of India, especially Article 124 Clause 2 and Clause 4 relating to appointment of Supreme Court judges and their impeachment. I explained that it is the President who appoints Supreme Court judges and it is the Parliament and the President together who can impeach a judge. This way, the independence of judiciary is uniquely protected by the Indian Constitution. Today, I will discuss other articles relating to the Supreme Court. Articles relating to Supreme Court are contained in Article 124 to 145. I will discuss only such of the articles which are in controversy and which are not procedural in nature. First of all, I will start with Article 125. Article 125 says that the salaries, remuneration and privileges of Supreme Court judges are decided by the Parliament by law. It means that whenever we say by law, we should understand that it is a combination of the Parliament and the President, the legislative and the executive. Unless both of them concur with each other, there cannot be any new law. Sometimes we may have to understand that Parliament itself refers to the elected members and nominated members of both houses of the Parliament and also the President of India, because Article 79 says that Parliament includes President. So it is the Parliament which decides the salaries, amenities and facilities and privileges of the Supreme Court. The purpose of my discussing these articles is only to inform you that it is the President and the Parliament which are supreme, under which the judiciary is supposed to work. I already informed you under Article 124(4), impeachment of judges is done due to their inefficiency and incompetency. And their inefficiency and incompetency or misbehavior are decided by the Parliament and the President. But such a powers are not given to judiciary over the legislatures. They cannot terminate the membership of any legislator. Such decisions will have to be taken by the President and the governors under Article 103 and 192. Under Article 126, when the seat of Chief Justice is vacant, who should conduct the functions of the Chief Justice of India? In such cases, it is the President who will appoint another senior judge as Chief Justice of India. Coming to 130 article, which speaks about the seat of the Supreme Court. It says that the seat of the Supreme Court shall be at Delhi or at any other place as the Chief Justice of India may decide, subject to approval of the President of India. Again, in this case also, the judiciary cannot function on its own. It needs the approval of the President of India. And who decide the jurisdiction of the courts? It is the Constitution. In the sense, it is the Parliament which decides. The original civil jurisdictions, civil appellate jurisdiction, original criminal jurisdiction, appellate criminal jurisdiction, and the writ jurisdictions under Article 32 and 139. And the procedures, these decisions the judiciary cannot take on its own. Article 140 reads regarding ancillary powers of the Supreme Court. Parliament may by law make provision for conferring upon the Supreme Court such supplemental or ancillary powers which are not inconsistent with the provisions of the Constitution as decided by the Parliament. The controversial article with regard to Supreme Court is again Article 142. Please see the caption of the article. It reads, enforcement of decrees and orders of the Supreme Court and orders as to discovery, etc. So the heading is that enforcement of Supreme Court orders. We know Supreme Court is a court of record and its judgment must be followed by the lower courts and its judgments must be implemented throughout the country, and all the government officials, I call them executive and public service, are supposed to help in implementing the Supreme Court judgments. So the very caption reads that it is meant for enforcement of Supreme Court judgments throughout the country without any difficulty. But unfortunately, it is misunderstood to mean that the Supreme Court can pass any judgment irrespective of any law or the constitution to render complete justice. But that's not the intention of this article. I will read out the text and you can make your own judgment. The Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such orders as is necessary for doing complete justice in any cause or matter pending before it. And any decree so passed or order so made shall be enforceable throughout the country in such manner as may be prescribed by or under any law made by Parliament again. And until provision in that behalf is so made in such manner as the President may order or prescribe. So basically Article 142 is meant to enforce the judgments of the Supreme Court, and they should be enforced in such way as the Parliament may by law decides, or in the absence of any law, it is the President who should decide how it should be enforced. So it makes clear to us that Article 142 is not meant to pass judgments, whether there is any law or not. Any judgment has to be passed only in accordance with the laid down law. This 142 is only meant for enforcement of judgments but not delivering judgments. Again, how it should be implemented? It should be according to the law made by the Parliament or until a law is made according to the directions of the President of India. Coming to Article 143, this states that the President of India, if he feels it necessary, he may refer. So the Supreme Court has the capacity to advise. He may seek advice, but the Supreme Court may report. You should understand the word used here, it is the report. Reporting function is always that of the inferior to the superior. President of India will not report to Supreme Court. The Supreme Court has to report to the President of India. Please see the language of this article. If at any time it appears to the President that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court. So it is the President who should feel that it is expedient, otherwise he may not seek advice also. He may refer the question to the court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. President will refer the matter to the Supreme Court, and the Supreme Court has to report to the President. Unfortunately, of late, we have seen none other than Her Excellency, the President of India, Draupadi Murmu, had to refer a question to the Supreme Court asking whether you have any right to decide upon the timelines for the governors to withhold assent or return the bills. When such a timelines are not prescribed under the Constitution, whether the court is empowered, whether the court is right in deciding the timelines. You know, when it has happened, when the Tamil Nadu governor has not assented to bills, and refer them to the President of India for his opinion. Some officer in the Tamil Nadu government or somebody on the majority on behalf of the majority leader has filed a public interest litigation in the Supreme Court seeking direction to the government either to assent to bill or return to the legislatures within a fixed time. The Honorable Supreme Court was pleased to specify a 3 months period, and it further said that if the bill is not assented or returned within 3 months, the bill is deemed assented to. In my opinion, it is not deviation, it is destruction of democracy and the constitution as well. After all, the bill is passed by the legislative majority leader. If you say that it must be assented by the executive, don't you understand that the word of the legislative leader is becoming law? He will become a dictator. He will loot all state resources. He will distribute all state resources among his party workers, friends and relatives and to others on quid pro quo. So this is not proper. There should be a separation of powers in a democracy between the legislative and the executive. We can never say that the executive is secretary or he should follow the advices of the legislative leader. In fact, the governor and the ministers should belong to one political party because they are appointed by him and removable at his pleasure. Sometimes he may have majority in the legislature, sometimes he may not. So the bill passed by this DMK party is the stand of that party, and its refusing is the stand of the party of the governor, namely the BJP or the NDA. Finally, it is the people who should judge in the ensuing elections whether the legislative leader who has majority in the legislatures was right in passing such a bill, or whether the executive was right in withholding that bill. It is the people who should decide the correctness of both the rival political parties. That is the beauty of democracy. Unfortunately, the right of the people is taken away. Coming to Article 145, which deals with the procedures to follow in courts regarding timelines for making appeals. In fact, it is the Parliament and the President who should decide upon the timelines within which an appeals may be accepted and what are the procedures especially to grant or refuse bails and rules regarding summary disposal of cases. So even including the procedures of the Supreme Court to follow in granting bails, etc., it is the Parliament which should decide. Coming to Article 146, the courts need to appoint some staff for its purposes. The Chief Justice or any other delegate may appoint such employees in the service of the courts. But if any outsider, in the sense who is not already in the service of the court, if such persons are to be appointed, the President may direct the court to refer the matter to the Public Service Commission. By these articles, we must comprehend that the appointment, the remuneration, the impeachment, and the extent of jurisdiction of courts, and appointment of staff in the courts, and procedures to follow in the courts, everything is decided by the Parliament and the President. So, the judiciary has to work to the satisfaction of the Parliament and the President, and the Parliament and the President will be answerable to the people. That is how the functioning of the judiciary and their independence was determined by the Indian Constitution. Without understanding that, unfortunately, we are going the wrong way, which is creating conflict, tussle between the legislative, executive and the judiciary. Thank you. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. I will be glad to reply to your worthy comments. I told you in my previous videos that it is my duty taken upon by myself to bring to the notice of Indian citizens the true constitutional content with fond hope that it may help change the social, political, economic order of this country. I have studied constitution for about 5 years and published 2 books, namely Indian Politics versus Indian Constitution, and the other in Telugu is Bharata Prajalamagu Memu. I have taken it as my life mission in the interest of 140 crore people of this country to bring to your notice the true constitutional content. I request you to please spread the message. Thank you. Thank you for watching my video.